Thank you for joining us at BigTent. As many of you know, we're a national women-led voter coalition dedicated to protecting democracy, women's reproductive rights, and our children and grandchildren's future through education and civic engagement. This is a busy time in the Trump legal world, with one case being decided by the jury right now and 3 cases in various states of delay. We're so fortunate to welcome tonight 2 lawyers who have been in the Manhattan courtroom for the entire hush money case. Norm Eisen is back for his record-setting 6th visit to BigTent, and George Conway is joining us for the first time. Norm, an American patriot, served as special counsel for ethics and government reform in the Obama White House, was ambassador to the Czech Republic, and advised on the first impeachment of the former president. Norm has founded several ethics and democracy-oriented organizations and is the author of a bunch of books, my favorite being The Last Palace. It tells the story of a century of European history through the lens of one special house in Prague. George is board president of the Society for the Rule of Law and hosts a podcast, George Conway Explains It All, with our BigTent friend, Sarah Longwell. George is a contributing writer at The Atlantic and was one of the founders of the Lincoln Project. We're honored to have you with us tonight, George. We have a very lively chat, as you can see, and it's part of what makes this community special. Please be chatty and please be respectful. Put your questions in the chat and we'll get to as many as we can. If you're distracted by the chat, you can turn it off on your screen. You can use closed captioning by turning it on at the bottom of your screen. And now, welcome George and Norm.
Thank you, Sue. Lucky number 6, the Norm and George friendship has been a wonderful portent of the bipartisan that's needed to keep our country rolling. George and I first learned of George when I was defending Clinton administration figures in the Clinton impeachment. And who is this guy, George Conway, who ghost wrote the Paula Jones brief? And it's such a treat to have.
Well, the big quote was, "No man is above the law."
To have called you a friend and a comrade in lawful and peaceful arms for years now, George. And thank you, since I'm the BigTent veteran. Thank you for accepting my invitation and the BigTent's invitation to share we've taken our Buddy Act to 100 Center Street, the Manhattan Criminal Court. We have vied for the privilege of who irritates Trump more when he sees us in the courtroom. We'll tell you those stories. And George and I wanted to share a little bit about this momentous trial that we've been privileged to see unfold, to study, to analyze why it's so important, what's gone on in the case, where we think it's headed, and how that fits in to the other cases. We'll talk about that a little bit, as well as the political ramifications, not to hide the lead, not to bury the lead. We think that the case is quite likely, although not guaranteed. I think George may be even more bullish than I am, and I'm quite bullish, to end in a conviction, and that it will be one of the most important democracy adjudications in our nation's history. So with that, I'm going to pass the, George and I will ask each other questions and talk, as you can see us doing any morning, starting around 7:15 in the line to get into the courtroom. We're on breaks. They don't actually let us talk in the courtroom, but otherwise we're chatting away.
They also don't let me. Everyone should buy Norm's book, but he can't bring it into the courtroom without a cover. Norm can tell that story.
No, my book. Now, this is a token of how much I love the BigTent. I'm not trying to flog my book. I'm just here to hang out.
Well, I'm going to flog it for you. I'm going to flog it for you. Flog it, whatever. Yes, it's a great book, and it's still going to be. You're probably going to have to do another edition, the conviction and appeal edition. And I'm looking forward to that. And you can sign that one for me too. But anyway, the story about the book is, actually, I don't have it. I have to go into the other room to get it. I'll get it while Norm is talking at great length. It has a cover of Trump with two New York State court officers on it and a big caption that says "Trying Trump" in red, black, and white. It's very dramatic. And one of the court officers saw it when I was sitting on the aisle, which I carefully select the aisle seat so that a certain person can see me when he comes in and out of the courtroom grimacing. And the court officer told me during a break that I can't have that out. It's like, no political materials in the courtroom. And I'm like, this isn't, and he said, no. And I just said, okay. I put it back in my bag and then came back with a cover for it. It's a trial notebook. I mean, I was going to say, I'm a lawyer. This is a trial notebook. It's got all the pleadings in there. Here you can see it. It's got a nice picture of a New York State court officer, just like you. Maybe he was jealous of the one that was on there.
Well, George, I thought that I would kick things off by asking you the first question. What was your expectation for this first trial of President Trump? Did you agree going in? Did you agree with those who said it's the runt of the litter? And how has the actual trial of you, as you have seen it unfold, comported with those initial expectations?
Well, I mean, I'm going to go back a little farther than that. I mean, I remember writing an op-ed with, I guess, Neil Katyal and Trevor Potter, who was a former FEC chairman, in 2018, where we argued that, no, this was a serious FECA violation, Federal Election Campaign Act violation, and should be prosecuted. Obviously, subject to the fact that the president can't be prosecuted while he was in office. So I always thought this was a real, there was real illegality here, just like there was in the Edwards case involving Senator Edwards like 15 years ago, whenever it was. And then, I mean, the New York State investigation started. They started focusing on all the other stuff, including his finances and taxes, and this sort of fell by the wayside. And I always thought it should have been prosecuted in January 2021 as a federal case, and it wasn't. And then it caught me by surprise that all of a sudden this case, after Alvin Bragg decided not to bring the big financial crimes case, that this all of a sudden resurfaced in 2023. I was like, huh? And I was a little bit worried about it, but I thought, oh, this is the case that's never going to get tried. It's going to be last in the queue because all the other cases are more important. Even Alvin Bragg says that. And so I didn't think much of it. And then when it became clear that this was the one that was going to go first, I was like, I bet they better have their act together. I guess I better bone up on New York law. And I was like, and there was a lot of skepticism out there, and I kind of was worried about it, although, Norm had written some great stuff over the years that showed that this was a real case that could be prosecuted under New York law. And even though I had thought that, there was a real underlying illegality here, at least under federal law. So I came in with mixed feelings when this became the first one up, and I began to re-immerse myself. And then I came to the conclusion that, legally it was sound. And even though it's not as serious an offense as attempting to destroy American democracy and stealing nuclear secrets, I readily concede that. I thought, in a weird way, and I wrote this up in the Atlantic a couple of 3 weeks ago, this is the perfect case because it's so sleazy. It's also perfect because this is how the guy got elected in the first place. And so I began to like the case more. And as I saw the evidence come in, I got kind of upset at some of the coverage because I thought the coverage was trying a little bit too even-handed in terms of saying, oh, well, Trump's got a good chance of knocking this off. And I thought the coverage on, CNN, however much I like the people there, has not been all that great, except for Norm and a couple of people. I came to the conclusion this is a pretty strong case, and they really, the defense didn't really put up much of a fight, and frankly they were, for reasons we'll probably talk about more, they were hamstrung, I think, by the facts, by the overwhelming evidence against Trump, but also by the client himself, who can't help himself, but caused his lawyers to do things that probably aren't in his interest. But anyway, that's my full and complete answer. Over complete.
Why do you think, George? I'll ask you one more, then I'll venture.
Norm usually does most of the talking.
A couple impressions of my own. Why do you think the coverage has been so uneven? And at times, you and I have talked about the difference between what people are saying outside of the courtroom. Some guy wrote a story the other day about how a juror was behaving, and he never set foot in the courtroom.
Yeah.
How do you explain this disjunction between the very strong case we've seen, I think 80% or greater chance of conviction, and what people sometimes say about it outside the courtroom?
Well, I mean, one because it involves sex in an indirect way. Two is because Trump is guilty of so many other things that are, that are more momentous. Like, as I said, just trying to destroy American democracy and stealing classified documents and committing obstruction of justice of a federal investigation into the stealing of those classified documents, tax fraud, he's a rapist. I mean, there's just a lot of other things going on, you might have noticed, with Donald Trump. So it sort of was odd that this became the first case. And it also it was because, this was part of a much, much larger criminal investigation that, it expanded from this into a large criminal investigation of him that ultimately didn't result in criminal charges, but resulted in civil charges that led to a almost $500 million verdict against him. So it sort of fell by the wayside, and I think it took some people by surprise, particularly since everybody had thought it was dead until some point in 2023, when all of a sudden it resurfaced, and the district attorney's office was serving subpoenas on people, including my ex-wife, and it took some people by surprise. And so I think that's part of the reason for it, and I think those are basically the reasons for it. And then there's also, the presumption of innocence, the reasonable doubt standard. It's a high standard for the prosecution to make. And then there's always like the feeling, I think, that people have that Trump always gets away with everything, which he has for 77 years, at least until E. Jean Carroll came into the picture. So I think there's a lot of reasons why, and then there's the, sometimes the media can't help itself. It does normalize Trump because it tries to put him in perspective, and they don't really know how to deal with a rampant psychopath and criminal like Trump. And so that's part of as trying to be even-handed, they end up giving him a break. So those are the reasons why. But I think it ends up, from my standpoint, I think it ended up being a good thing because it lowered expectations and lowered lowered the risk involved. If there's a hung jury, it's not going to be as beneficial as if everybody had assumed that a conviction was always imminent. And then I think it's going to have more impact if there is a conviction, which I think is fairly highly likely. And I think the press is interesting over the last 48 hours. I've been watching snippets of it and listening to people. I think they're finally catching on. Like, this is real. This guy could be a convicted felon by 5 o'clock on Friday, if not early next week. So if not tomorrow, it could be early next week. But my bet is, I just have a feeling about Friday afternoons with jurors. But
Friday after jurors love to tie things off on Friday afternoons. But on the other hand,
like the rest of us,
as the very speak for yourself, I'm just getting rolling on Shabbat on Friday afternoon.
Oh yeah, sure.
But I thought today's proceedings, with the note coming out from the jury And then while we were getting ready to answer the first note, we got a second jury request to have the legal instructions read back to them by the judge, which was an 80-minute adventure. And all that evidence in response to their 4 questions is going to have to be read to them. I think we're likely seeing a jury that's going through the evidence in chronological order and that will utilize its time for the rest of the week. They could finish, but I won't be alarmed, and nobody in the Big Tent should be alarmed if you don't get a verdict by Friday afternoon. I agree with George that is if I had to pick one date right now, that's the most likely one. I'm going to say one word about my impressions of the trial, and then I'm going to, with George, answer the first of the questions that are coming in, which is, I see there's a question about this 4-part question that the jury asked. Maybe we'll roll in a couple of other questions as we go. I think it is very difficult. Part of the reason that the coverage has not been uniform is that it is very difficult for even experienced trial lawyers. Between us, George and I have, as evinced by our Clinton experience on opposite sides, between us, we have well over a half-century of litigation experience. Between us, it's very difficult. Oh, and for the first time ever, we share an office. We rented a little temporary satellite office down the block from the courthouse, so we have a place to go. The law firm of Conway and Eisen. I think it's very hard, even for experienced trial lawyers, to read what's going on in a trial if you're not seeing the inside of the courtroom. You're not observing how the prosecutor is performing, the exact words of the defense lawyer, what the tone is of the judge when he upholds or overrules objections, and above all, the demeanor of the witnesses, their credibility or lack of same, and the jury's reaction to everything I've described and so much more. And I was trained as a trial lawyer to be attentive to everything in the courtroom, to multitask, but above all, to watch the jury. And while you never know for sure until you get a verdict, there were so many moments in the room that that led me to believe that the odds of success were much higher than anticipated, that supposed gotcha moments or Perry Mason moments like Michael Cohen not remembering part of the October 24th conversation with Keith Schiller and Donald Trump, that this was a jury that got it. And much like George described his history with this case, I have a history too. Cohen was my witness, the first witness I interviewed for the Trump impeachment before we had the Mueller report, well before we had the Mueller report, because Cohen was such an important tour guide. And I believed that he would exceed expectations, George. I think that was our shared judgment before his testimony. And he did that. But so importantly, he was corroborated at every turn. And that brings me to the juror note today. One of the key insights of the prosecution was, in this critically important election tampering case, hiding this information from voters in 2016 and then covering it up, election conspiracy, voter deception, and cover-up is the exact model for what happened in 2020. That's why I refer to this, the subtitle of that book is Trump's first election interference case. There it is. Oh, that's where you went, George, to go get the book. Yes, there it is. Right. It was
available at Amazon.
It's a complete guide. It's somewhat of a legal aficionado's book because it was meant to guide us through the trial above all
But
those of us who
does
were
have
covering
some
it.
pictures though.
It does. And that's some of the most damning evidence.
Yeah.
So the questions today were all focused on Pecker, with one question on how Pecker corroborates Michael Cohen. They asked for Cohen's testimony to compare and contrast. And they wanted to know Pecker's recollection of how the conspiracy was formed and how the conspiracy initially developed with the payments to Trump's other paramour, Karen McDougal, with whom he had a more sustained relationship, and how Pecker and Cohen's testimony compared and contrasted. And I thought that was such a positive sign for the prosecution, in part because Todd Blanche, Trump's lawyer, offered a number of off-ramps. You don't have to reach the conspiracy if you decide the documents were not false, or even if the documents are false, if you decide Trump wasn't involved in the document creation, didn't act intentionally. They sped past all that right to the conspiracy. And they asked for this corroborating witness. The jury believed Pecker. I think they believed and trusted Cohen, but they're doing their job to get corroboration. So I think that's a sign. I handicap this case at well over 80% chance of conviction. Not a slam dunk case. It was never going to be an easy case. Mark Pomerantz wrote a whole book about how he wasn't willing to take the risk of bringing the case. He's a friend of mine. I'm not criticizing Mark. That's good. There's a very experienced judge that I sit with. He's become a pal of George and mine, the other George Grasso, who was the chief judge of the criminal division next door in Queens. He thinks it's now over 90%, including after this note came back, which is a lot. The other percentage, the other risk is of a hung jury. Juries hang in about 5% of cases. I think, somewhere twice that risk here. I do believe that there were a lot of ways this case could have gone south for the prosecution. Almost everything went right for them. And the defense did a very good job, except when Trump got in their way, like with that disastrous final witness who the jury hated, that Trump reportedly insisted on, Robert Costello, in my view, allegedly, the allegations that he was attempting to tamper with Michael Cohen to intimidate him on behalf of Trump are backed by some very damning emails. So that's kind of my overview of the case, of where we are, why I'm optimistic. And I'm going to pass back to George to give us his percentage of success. We'll talk a little bit about sentencing and appeals, and then we're going to wade into some of your questions, starting with those about, there's a lot of questions about Judge Cannon, so we're going to talk about that. George, what do you think the odds are?
Yeah, I think when the prosecution rested, I was at 70 to 80. After the defense case, which was counterproductive, I was at probably 75 to 85. And now, after having marinated in a couple more days, seen excerpts of the jury charge and understand it a little bit better, and I wasn't there for the summations. I was unlike Norm, who has basically been there 21 out of 22 days. I was there probably for 4 or 5 days max. But that was enough to give me a feel for what was going on in the courtroom and to be able to interpret the transcript and what I was hearing in the media. And I did see a couple of critical moments, like that moment where they did score a couple of points off of Cohen, and then they gave him back later. And then the the cross-examination of Costello, which was a complete disaster coming after his misbehavior the day before, which I didn't see. But by now I'm with Judge Grasso. I'm at 90%, and the other 10% is not. There is zero chance of an acquittal. Zero. I will take that to the bank. If there's, across the board acquittal. I think there's a 10% chance of the jury hanging on some of the counts, or some or all of the counts. Not all. Yeah, some or all of the accounts. If that. And I just think there's just I just think there's an overwhelming likelihood that this man is going to be a convicted felon pretty soon. I concur in all of the more specific observations that Norm made. I will add that I didn't think, I thought that Trump got in his lawyer's way on more than just the putting on Costello as the only substantive witness on the defense case. Which was pretty bad. I think that they made a couple of really, really bad errors that hurt their credibility. And basically, one was to contest the truth of the claim that of the fact, basically, that Trump very briefly had whatever he had with Stormy Daniels, and then also the claim to deny that he reimbursed Cohen. I mean, first of all, it just wasn't, neither of those is credible. And the second point of the reimbursement is contradicted by Trump's own words and by the overwhelming documentary evidence. You don't have to listen to Cohen. And I think they lost a lot of credibility in terms of the forensics, the way, the trial, the way they conducted the trial as lawyers. I thought, I think Necklace and Bove are the two more skilled lawyers. I don't think Blanche, who was the lead lawyer, is as skilled as those other two.
And the jury doesn't like Blanche as much as it likes Necklace and Bove either, because they're more entertaining. Blanche bores them.
Blanche is boring and he's obnoxious.
He's obnoxious. He shifts. It's like the worst of both.
I
don't want to be too severe on him, but he has had boring and obnoxious moments.
Yeah, he had plenty of obnoxious moments, and I like Necklace. I would, if I were ever in the dock, I'd hire Necklace in a heartbeat. But I thought her cross of Stormy wasn't that great, but not because of her. She knows how to ask a question. She knows how to conduct herself in court, and she's a really, really smart person. The problem was there was no need to go after Stormy. It was totally counterproductive. And the more you go after somebody, the more you attack a witness, the more you can have the witness has a lot more leeway to come back at you. And Stormy, you give her the chance, she'll roll right over you because she's very smart. She's about 5 times smarter than the defendant, 10 times probably. And she just rolled over Necklace when Necklace pushed it too far. And there was no point to it because it didn't matter whether or not there was an affair, except to the extent that it added motivation for Trump to pay the money. But the defense should have just said, it doesn't matter. What matters is how this was accounted for, what happened, and what Trump knew about it. So that was bad. And then I thought the cross of Cohen was pretty bad, ineffective, because it went on too long. It was too obnoxious. It basically didn't concern the facts of the case by and large, except for that one contested bit about the phone call on October 24, 2016, where Cohen was caught off guard with text showing that he did call what's his name, the bodyguard, what's his name?
Keith Schiller.
Schiller, yeah. At a time when he had another piece of business to conduct with Schiller. And so that kind of threw him off. But then the prosecution came back with video that Schiller and Trump were together. And obviously when one way to get in touch with Trump is to call the bodyguard. And then in the closing, yesterday. They did a brilliant job. Steinglass did a brilliant job of showing how Cohen could have had both conversations in the span of a minute or two with both individuals. And I just blew it away. And I thought the problem with the cross of Cohen was it just meandered all over the place. That was the one good point they have, and it got buried because Blanche was so obnoxious and going on and on about stuff that could have been done much more crisply and much more effectively. And it got buried in all of that stuff. And then, by the end of the day, he had that one good piece across with that phone call. And then in the afternoon, he's obnoxiously asking Cohen how many stories Maggie Haberman of the New York Times wrote about him, which was neither here nor there. It was just, I just thought he did a terrible job. But I think that partly was because his client was the same way pushed Nicholas into attacking Stormy was, he had to show his teeth. He had to bare his teeth in front of the client, or the client wouldn't have been happy. And then the client goes and watches Fox News, and Fox News is all a Twitter about this guy Costello, how, and they're all the dumbass commentators on Fox are saying that, oh, this is the kill shot witness. And, Trump falls for that, and against his lawyer's wishes, I suspect. Norm may have heard more about that. They call this guy, and he just completely blows up on the stand. They did not do themselves any favors, and it just got worse for them as the trial went on. That said, they could still, all they need is one nut job juror who's determined to hang the jury, and then this case would get retried. I just don't think it's that easy to get that. And with the overwhelming evidence, and there's just going to be a lot of pressure to come to a verdict. And even if they split the verdict in some way as a compromise, I mean, how can they not convict Trump of the 9, 18, or 27 counts, depending on how you look at it, that basically relate to checks that he himself signed with the backup attached? And he's going to get convicted of a substantial number of at worst case, he's going to get convicted of a substantial
George,
number.
I'm going to use that as a jumping off point to do a speed round for the questions that we've gotten on this case. Okay. And then we're going to talk about sentencing, political impact, and some of the other cases. Okay. Question comes in, could he be found guilty of just some of the counts? And then what happens if the jury decides to compromise? Short of that, I think extremely unlikely hung jury eventuality, a natural breaking point is the 9 checks that Trump signed. 9 felony convictions would still be extremely serious. That is one thing to look out for if the jury feels they need to do a compromise. You never know what goes on in the jury. And that 9 could be 18
or 27 because there are for each check there were 2 additional, except for the first check. For each check there are 2 additional pieces of paper. So it's either you could say, oh, we're just going to hold him liable for the checks he signed. That could be 9, 18, or 27 counts of the 34 because he signed 9 of the 11 checks.
What's the possibility that even one juror has been contaminated in some way? There's always a risk that you have a juror who is going to do what we call jury nullification. They're going to disregard the law, disregard the evidence, and decide because of bias for one side or another. And when you have such a prolific merchant of disinformation as Donald Trump, that risk is always there. The jury process, voir dire questioning the jury, is there to screen it out. That is a very rare thing in my almost 40 years of going to court. And we know a lot about these jurors. George and I were there for the jury examination. I have pages and pages of detail, some of which I can't disclose under court order, can't disclose publicly. I don't think there's a sleeper juror that's been contaminated here. Yeah. Closing arguments. One of our guests asks, how were the closing arguments? I thought that it was Todd Blanche's best moment for the defense. The prosecution, though, was superb. There's a mountain of evidence, and they took the jury up that mountain. Like any hike, it was tiring at times, but I thought it was a necessary and a worthwhile trip. was well done, even though I still can't believe the prosecutor made the jury stay till 8 o'clock at night. That was
They didn't seem to mind, though.
No, they didn't. They said they would stay, and they till 8. They paid attention, and we're lucky he finished by 8 because there's a lot of evidence in this case. So there's a couple questions here about our encounters with Trump. I will tell you, my encounter with Trump was he saw me on an early day of the trial when I happened to be sitting on the aisle. It's just the luck of the draw, in a position where he couldn't miss me. And he pointed at me. He made eye contact. He gave me the Trump death glare. Then he did it. He did that on the morning break, and he did it again on the lunch break in case I didn't get the point. George, do you want to say yours?
Yeah, he I think the day after that or 2 days after that, he saw me. I was sitting on the aisle, and he glared at me, and then and walked out. And I just gave him, I smiled the pearlies, like that, and he didn't like that. And then I think every time he came into the courtroom and saw me out of the corner of his eye, he looked away. He didn't want to look at me after that. Although the other thing he did, though, is one day, I think he saw me, and again, every time he's walking in and out, I'd smile. He might have seen me out of the corner of his eye. I didn't see whether he was looking at me closely, but during the lunch break, he sent out a Truth Social post, not attacking me. It was 2 photos, one from election night 2016. One of them, I'm totally shit-faced. Sorry about that word, but yeah, I was totally trashed, hugging my wife because she just won a presidential election. I had no freaking idea what was to come. I regret to say. And then there was another picture of me in the war room from that night, watching the returns. And he sent that out with a caption saying, "Mr. Kellyanne Conway celebrating my great victory in 2016. And I mentioned that in an Atlantic article I wrote saying, "Gee, you sure know how to hurt a guy." So, and then he had one of his minions, Boris Epstein, who's a defendant in the Arizona case, hand printouts of those pictures to Caitlin Collins of CNN and said, "Here, go give these to George." And she looked at him like, "What? Conway?" And she looked like she completely, like, all the reporters were looking at like, what the F just happened there? It was bizarre. But he can't help himself the way he went after Robert De Niro today. He cannot help himself. And that's one of the great things I think about a conviction, is not just in terms of the rule of law, which is, Norman, I think that's important, but he can't handle this. He reacts to everything. He cannot handle this. And it needs to be rubbed in his face that he's a convicted felon, that he's an adjudicated rapist. And it has to be hammered at him by many people. And it's going to drive him nuts and drive him to distraction. Anyway,
George,
that's my theory.
What about the sentencing? Let's assume that we're right in our predictions. I'll note that it's not a slam dunk. The range, I think my estimate has probably gone up to about 85%. I'm not quite at the elevated 90 level, but I respect Judge Grasso, who felt that that's where we ended as the jury retired for
and let me
deliberations.
just say about Grasso, I had a conversation early on in the case, and he didn't strike me as gung-ho about it.
No.
I mean,
no, he has genuinely gone on that journey with the jury, and he hadn't studied the case as closely as you and I had. He came to it cold. He learned it, and he's now, but he sure studied it once he was in court every day.
He learned about the case the way judges learn about
notebooks. He filled his notebooks with notes, and I take his assessment very seriously. If George, I want to ask a question about if Trump is convicted here, as seems likely, and sentenced, I believe that there's a significant chance, I wrote in the New York Times, that he will get a sentence of incarceration. He'll be let out pending appeal. Do you see a possible jail sentence, and how likely is that, having
Yeah,
observed Judge
I,
Mershon as you have?
I think it's highly likely. And I mean, if he's convicted on 34 counts and the way he has conducted himself in the courtroom, the way he has disrespected the legal process, the jury, the court, the rule of law generally, his complete lack of acceptance of responsibility. I don't think he's going to accept responsibility even after a conviction. Could be wrong. Uh, I don't see, and you know, I just don't see any way he gets a break in sentencing. I just don't, you know, there's no, if you just apply, I'm not a criminal lawyer by trade, but you got to have something to say about why, you know, why you should get a break on the sentence. We get a light sentence or no incarceration for a felony. And I don't know what his arguments are going to be other than, you know, witch hunt. That's not going to work. Witch hunt's not going to work. Rigged case is not going to work. All the stuff he's been saying out to the public, lying about the case and and he violated the gag order 10 times. I don't see how he gets a pass on jail. I just don't.
I think he's a first time offender.
Well, that's about it. Well, I don't. He's an adjudicated rapist and is on 4 other counts.
I've studied the cases. I like doing these with George because, you know, it's the one time that I can be the case. A slight note of case skepticism. I do not think it is assured. I think the odds of jail time are less than the odds of conviction, but I think they're substantial. There'll be a lot of talk about that, BigTent friends, if we do get a verdict as soon as tomorrow or Friday. Bear in mind that even if he gets less than a year, now I'm going to walk and talk, and George is going to hold down the fort because I'm going on Anderson Cooper, but I've given you all my best material. The bear in mind that if he gets less than a year, which is certainly possible, he spends that on Rikers, most likely. That is a jail sentence which is served on Rikers. So I think that the case is strong on appeal, and I do think there's a substantial risk, and I wrote for the Times why. George, I think the group would like to hear from you. I'm still going to be on. I'm going to lurk for another couple minutes. I think the group would love to hear from you on the other cases. Start with Judge Cannon because that's so hot. And if you don't mind, talk about the January 6th case in DC as well. Would you please?
Yeah. All right. So the case that should have gone to trial by now and would have gone to a conviction for any normal judge in their normal court would be the documents case. It is as open and shut a criminal case as you could ever imagine. It's like a buy and bust drug case where the drug bust is caught on video by the FBI. I just don't. There is just no defense there, and these are, you know, substantial crimes, Espionage Act, obstruction of justice. I mean, this guy should have been convicted by now and should have gotten a sentence of 10 or 15 years by now. And it's just atrocious that it has not, and it has not because of the luck of the draw. He got this judge, Eileen Cannon, who is one of the 4 judges out of a very large court of the Southern District of Florida, United States District Court there. But since the case was venued in Palm Beach, filed in Palm Beach, where the crimes occurred, it was going to be dished out to one of the 4 judges who sits on cases in Palm Beach, and a couple of them are senior judges. One of them is Eileen Cannon, who sits out in Fort something or other. I forget the name of it, Fort Pierce. And it was just the luck of the draw. And he basically probably got the one judge in the entire federal system of 600 district judges, 600 or 700 district judges, who's ready to cut him a break, and who's just not, apart from, I think, her obvious bias against the prosecution, I think she's dumb as a rock. I mean, she absolutely has no idea what she's doing. Actually, she's probably smart from a an IQ test standpoint, but she doesn't know anything about what she's doing as a judge. She appears to be extremely inexperienced, particularly in criminal cases, and it's just a very bad combination. And the real question is going to be, and she's conducted herself atrociously and has gotten reversed by the U.S. Court of Appeals twice early on in the case, when she basically tried to block or impede the Justice Department's investigation for myriad reasons, which just is unheard of. I mean, I think that I think she's got to get removed from the case. I don't know whether that's going to be possible. It's very difficult to get a judge removed from a federal case, but she's in the running for that, the way she has conducted it. And I think that Jack Smith is now waiting for the perfect opportunity to take her up to the Court of Appeals on something else, and then basically document every crazy thing that she's done, and hope that the Court of Appeals has the gumption to say, okay, we're reassigning this to another judge. But we'll see. So that's the documents case. And the other case is the other
George, I'm
federal
going to just
case.
jump in with a question on that.
Yes, absolutely.
If they do take it up to the district court and she is removed, what would the timing be? Would there be?
But this case is not. There is no way at this point that this case is going to get tried in 2024. It is not going to happen. Even if she is removed tomorrow, it's not all that likely. She has burned up the clock substantially, and it's just hard to see the case getting to trial this year. Impossible, really. And to get her removed off the case is going to take, assuming she does something insane tomorrow and they take an immediate expedited appeal to the 11th Circuit, it's still going to take several weeks. And then it would have to be reassigned to a new judge. There'd be proceedings before the new judge. There's just no way this case is going to get tried, or before the election. A more interesting question is whether the case, the January 6th case in D.C., here in D.C., I'm in Maryland today, will get tried before the election, and that hinges upon the Supreme Court, which seems to be doing. And I don't know whether this is an intentional play on the part of some of the justices, but they seem to be doing their level best to slow the case down. They're clearly, the Supreme Court is, they've heard argument on the question of whether Trump has any form of immunity that might protect him from some or all of the charges in the case. And I don't see the decision coming down, even though it probably should have come down earlier. I don't see it coming down before the end of June, when they go home for the summer. So that's June 25th. Now, if there are no wrinkles to the decision and they say, oh, well, the case can, certain parts of the case or all of the case can be tried, and there's no fact finding for the district court to do, then a reasonable possibility is that 80 days after that, 81 days to be precise, because that was sort of the lag between when the appeal was first taken and the time spread between when the appeal was first taken and when the case was originally scheduled to go to trial. And the judge seemed to have said at one point that she was going to give them a 1 day for each day delay, so that 81 days would put you in September or October. And it's possible that there could be a trial in the middle of the election campaign on the January 6th stuff. I used to think that was a desirable outcome. Maybe it's still a desirable outcome. I'm starting to think it may not be, because of what has happened during the current criminal trial involving the New York case, which is he's been helped by that, and not for the reason that I think a lot of people assumed he would be helped, like it would bring together the Unite MAGA in his favor. So the reason why it has helped him is because it has kept him off the campaign trail. It has put the campaign in kind of a weird stasis, and people are not really focus on Trump. Even with this criminal trial, the election has not yet become about Trump and his behavior because we haven't seen much of Trump and his behavior. I mean, sure, there are these, he have a speech, these speeches here and there, but nobody really watches them. And I think that's why the Biden people decided to hold an early debate, because this man is certifiable. He is completely out. I've written, he's a narcissistic psychopath, and you push his buttons in the right way. He is worse than ever. People are going to see he's absolutely nuts, and I think the Biden campaign gets that. And the more they see of Trump, the better the more he becomes an issue, the issue. He wants to be the issue because everything's about him. And whoever, this is what happened in 2016. The election was about Hillary. She lost. 2020, the election was about Trump. He lost. And the election is going to be, if the election is about Trump once again, which it will be, I think, once this trial is over and he's out there on the campaign trail and he's, on a stage with Joe Biden and behaves the way he behaves, and he's worse than ever. I think things are going to go south for him the way they did when, the reason I remember like it was yesterday when the White House had to pull those coronavirus briefings because he was making such an ass out of himself talking about bleach and whatnot. So the more I think the public sees of Donald Trump, the better. I think a negative aspect of the current trial, to my surprise, which I would not have thought, was that it has kept him off the public radar screen and has basically frozen, postponed the commencement of the election cycle in a weird way. And I think, that's going to resume next week with one side being able to call the other guy a convicted felon, I think. And it's going to be very interesting to see how that dynamic plays out.
Just in the
George,
go ahead, Norm.
Just do a little bit on the Alito situation and on Fani Willis. And friends, I'm going to say hi from the Big Tent to Anderson, who's going to arrive in the chair next to me in about 60 seconds. And
Trump called him Allison Cooper the other day.
I saw that. Have we ever had a Big Tent that has broadcast live from the set of
well, the lighting is improved. It's very nice.
CNN
the lighting
AC
is
360.
Not yet.
All right.
So
Thank you, Norm.
Thanks, friends. George, passing the baton. Thank you for joining me and my Big Tent pals.
All right. Say hello to Anderson. Okay, so Alito. I mean, I am just at a loss on that one. I think it's just completely insane what has happened there. I think it's a pretty good basis for recusal. He's not going to do it. There's no there's no basis to make him recuse if he doesn't want to recuse. There's no mechanism for that. I think what happened was just shocking. And I just don't see a justification for it. It may be true that his spouse was largely responsible for it, but he's got a higher obligation, which is the appearance of propriety, the appearance of impartiality, and that has been greatly damaged by these revelations. Now Georgia, to talk about and we'll see how this plays out. We'll see how he comes out on the immunity case. It's going to be very, very interesting to watch. I am hopeful on the immunity case, by the way. More hopeful than a lot of people. I think they're going to allow this case to be tried. I think they're just concerned, and actually understandably, about how far you can say that a president doesn't have immunity, because you could end up with a president in the not too distant future who's determined to prosecute former presidents for no good reason. And so there's a real question about whether or not the idea that there's a real question about whether or not you can say there's an absolute no protections for former presidents. I think there's a different way to skin the cat. It's too long to handle it, but it's too long that this will require another 60-minute episode. So we'll see how that goes. The Georgia case, I mean, the problem with the Georgia case all along, I mean, I give Fani Willis and her team credit for being ambitious and bringing that case and showing courage to bring that case. The problem with that case has always been the positive and the negative is that it is a broad case with lots of defendants, which means it takes longer to try. And then there was the misstep with the relationship and the hiring of Mr. Wade, and that probably, I mean, absolutely could have been handled better. I mean, there are plenty of lawyers to hire. Having a relationship with one should, it was not great. And then I think the way it was handled and getting defensive about it, they should have just said, oh, we're gonna, on day one, when those allegations came out about the relationship, they should have said, we don't think there was any issue here. There's no conflict here. But that said, we want to eliminate any issues, and he should have resigned right then. And I think everything would have gone much more smoothly. It would have gone, there wouldn't have been this extended hiatus. So I don't, that case is not going to get tried this year either. I think it's basically the only other case that's going to get tried this year that has a chance of being tried this year is the case before Judge Chutkan here in the District of Columbia, the federal case with Jack Smith, which is a rifle shot case of just one defendant, Donald J. Trump. We'll probably see if Trump does not become president. We will probably see more cases by Jack Smith involving January 6th brought next year. I'm hopeful that case can get tried this year, although I am concerned now that it's going to be as much as a distraction during the fall campaign as it would have been a moment to inform the American people about what happened on January 6th and to remind them. And I don't think in any circumstance, even if the case is tried starting in September, I don't know that it's going to get the verdict before November. That said, there's one other possibility here I want to throw out about the January 6th case that I didn't mention is if the Supreme Court says that there has to be some additional fact finding to determine what parts of the case can go and what parts of the case can't go under whatever holding they make on the question of immunity. One of the things that Judge Chutkan could do is basically say, okay, fine, it's June 26th. I have the Supreme Court's decision. Let's have a conference. And I think what they're requiring me to do is to hold a mini trial where I get to hear the evidence so I can make these findings determinations. And Mr. Smith, come back here in 10 days and call your first witness. And you'd have a mini trial that would air the events of January 6th and Trump's misconduct relating to January 6th and the false electors scheme and everything else could be aired in full in open court in the summer. Maybe that's another one of my Pollyannish notions, because I'm more Pollyannish than even Norm. But that's possible. If it does happen, you can say you heard it here first.
And we hope you'll come back to talk to us about it if it happens. Yeah. So thank you, George. This super insider review was really incredible. We would love for you to come back to talk to us.
I'm happy to do that.
Anytime.